Hello, everyone, and welcome to our third and final international employment webinar on the topic of cross-border working in the modern world. Thank you for joining us this morning. Today, we'll be tackling the question of, that employers are being asked increasingly, I would like to relocate abroad, but I would like to keep working for my employer remotely. Am I permitted to do this? Now, COVID-19, of course, saw a massive shift to remote working and different working patterns. And previously, you'd have employers saying to an employee, we want you to locate yourself in another jurisdiction. But now we're finding it's the other way around. Employees are coming to their employer saying, my partner's relocating, or I'd like to spend the summer in a certain country, etc. Please, can I work for you from abroad somewhere? And this gives rise to several considerations and challenges for both the employee and the employer. And today we'll be focusing on the implications where an employee is based in France, Spain, and Greece. Those of you who've attended previous webinars will know that we've covered other jurisdictions in the past. Before we go into the detail of all those jurisdictions, I'm going to give an overview. And apologies for those of you who've attended previous webinars. I'll be covering very similar ground to what I did previously. Just a reminder to everyone that we will have a chance for Q&A at the end. So there is a Q&A tab at the bottom. Please do submit your questions via that. Please do put your name, because if we run out of time at the end, we can always come back to you separately and afterwards in respect of your questions. So please do use the Q&A tab, and welcome to you all. Now, regardless of where the employer is based, where the employee is based, there are certain things that all employers need to think about and consider as to whether they are relevant for that jurisdiction in respect of an employee working across borders. And they're listed there. And looking at each of them, firstly, and one which is going to be a key focus today, is employment rights. Because where an employee is based in a different jurisdiction, regardless of the law of the contract, they may acquire employment rights in that jurisdiction. And often this is based on where the employee is based or where they're performing their services. So you could have an English law employment contract with an English employer, but if the employee is based in Germany or France or another country, they may well acquire rights in that jurisdiction. So that's the first thing you need to think about, because they may have different rights there to what you have in your jurisdiction. There might be different rights in terms of holiday, severance or redundancy payments, employment protection. It might trigger certain benefits in that jurisdiction, such as pension, and whether the employee is even interested in that, or whether they prefer a payout of some sort instead. So these are all relevant considerations. The next thing to think about is straight from the employment topic, which is going to be our main focus today, but I don't think you can tackle this topic without at least thinking about the tax considerations. And there is a risk that employees working in another country will create a taxable presence, such as a permanent establishment in that country. And the rules, of course, are determined by the country in which the employee is based, but the risk is greatest where they have a fixed place of business, such as an office, or they have the authority to conclude or negotiate contracts in the name of the employer, bind the employer in some way. And this can create complications, risk of double taxation. In particular, there's an establishment that might create a corporation tax risk in that country. There's other tax considerations as well, mainly for senior employees. For example, you could have a VAT risk if they're providing services from that jurisdiction. It could impact on the company's tax residence if they're a director and they are consistently attending board meetings from that jurisdiction, or perhaps even a withholding tax risk in respect of loans. Now, as I said, our focus today is employment, but we do think that tax is an important consideration. It must be a question that you should be asking your tax advisors if you're faced with this scenario. Now, tax in a more employment context, of course, employees, they pay tax and social security contributions, and if they're in that jurisdiction of the employer, it's quite straightforward. So a UK-based employer and a UK-based employee, the employer will make deductions for tax and account to HMRC for this. But where they're cross-border, where does that responsibility lie? Does the jurisdiction in which the employee is based require the employer to register with the tax authorities? Does it require them to have a physical presence there and make those deductions? Or can you pass that on to an employee? And if you can, do you want an indemnity in your employment contract from that employee to make sure that they are making those deductions? Also consider whether there's a double tax treaty in place or exemptions from Social Security. The A1 form in Europe, of course, is relevant. Now, the other key factor is immigration. The employee might want to be based in another jurisdiction, but can they have the right to live and work there? Can they get a visa? And often many countries require the employer to be registered in that jurisdiction in order to get a visa for that jurisdiction. So, for example, in the UK, the employer has to register with the Home Office in order to get that visa. What is the rules in that particular country? Also, thinking about it the other way, if an employee is based in a different country from the employer, have they got a visa to enter the the employer's country to work if they have to? For example, a UK-based employer, if the employee has to enter for a month to do some work because the employer requires them to, can they do that? If they're entering as a business visitor, because they're not permanently resident in the UK, they're only restricted in what they can do. So you'll have to think about that angle as well. And of course, where you get situations like this, where you've got complications and cross-border working, you're going to get organizations that come in to try and fill that void. And you get the rise of the professional employer organization, or the employers of record. And we're seeing more and more companies coming in saying, we can fulfill these needs. We can help you with onboarding in a different jurisdiction, payroll, we'll do the employment. We'll effectively hire these employees and either work for you as a consultant or second them to you, and we will run all the local administration and taxes. And that, on the face of it, of course, is very attractive. But think about the consequences of engaging these companies, some of the difficulties you might face. First and foremost, for example, what contract will they have with this employer of record? Because will it be as comprehensive as you would have? For example, would you have confidentiality provisions, IP provisions, etc.? And do they protect the employer of record, or do they protect you as the real employer, the person benefiting from their services? The next thing is review the contract with that employer of record to see where the division of responsibility is. If the employee brings claims, has issues, where does that liability lie? Who's responsible for the disciplinary or for running a grievance, for example? Also, does the jurisdiction in which the employee base have this concept of dual employer? Will they look beyond the contract and actually look at who the real employer is? Or does that country even basically not permit this employer record scenario? And some of the other issues I've highlighted, like immigration, having an employer, but to sponsor the visa, you don't necessarily get around that by having an employer record. So you do need to think about whether this works for you in a particular scenario. Now, finally, I just want to talk about a few practical matters. Of course, there's other things to think about where you've got an employee based in a jurisdiction, in different jurisdiction. What public holidays will that employee have? The public holidays where the employer is based or where the employee is based? What about working hours? Where it's across Europe and it's only 1 hour time difference, you might be okay. But if the employer is based in France and the employee is based in Dubai, there's several hours difference. Will they work local time or will they work the employer's time? And if they're working local time, does that work? Think about your health and safety obligations. Obviously, that can be more complicated if the employer is in a different country. And also think about the benefits you're providing, insured benefits. Does the private medical insurance, for example, extend to employees based in another jurisdiction? And if not, what are you going to do? Are you going to give the employee an allowance? Are you going to get them insurance in their jurisdiction, which might be quite expensive? Or are you going to just say they don't benefit from that? And of course, data protection issues. So that's my roundup. Now we're going to hear from each of the jurisdictions, and I'm going to start first with Ariane, who's counsel in our Paris office, to talk about the view from France. Over to you, Ariane. Thank you.
Thank you, Devan. So immigration issues and employment authorizations. So for EU citizens exercising a professional activity have the right to live in France without holding a resident permit, but with just a valid ID or passport. It's not the same situation for non-EU citizens for whom a work permit is required, notably the intra-corporate transfer for 3 years or the ICR temporary trainee residence permit. And the last one is a temporary worker resident permit. What status for the foreigner working in France? Some rights are guaranteed to seconded employee in France, and there is a principle. So there is an equivalent treatment between the seconded employees and the French employees. A guarantee of core of rights, such as the first one, individual and collective freedom, and notably the right to benefit from direct and collective expressions through staff representatives. The second one is a non-discrimination and professional equality between men and women, particularly regarding remunerations or benefit in kind. Despite that, women's remuneration is still 15% lower than men's one. The third core of rights is the right to strike, which is a fundamental right in France. An announced strike, for example, as thus lawful. And maybe the most difficult core of rights is about working hours, public holidays, or paid leave. All regulations relating to working hours, daily hours for 11 hours per day, or weekly rest period, which is 36 hours per week, maximum daily working hours for 12 hours per day, and weekly working hours for 48 hours, also apply to seconded employees. Working time. The legal working time in France is 35 hours per week. All hours worked about 35 hours must be paid as overtime at an increased rate, such as 25% for the first 8 hours and 50% for all hours above that. The work time is limited to 22 hours per year and per employees, except if a lower quota is mentioned in the applicable collective bargaining agreement. There is also a system of fixed weekly working hours or monthly working hours, and a fixed annual working day for 218 days per year. The last system only applies for executive employees who have a large degree of autonomy in the organization of their working time. In this system of annual working days, there is no overtime, even if the employee worked more than 35 hours per week. Another core of rights is about remuneration, payment of wages, including increase for overtime, which also apply to the seconded employee. Risk and sanctions related to the core of rights. So for an employer failure to comply with legal requirement, there is a penalty up to 4,000 euros per employee. And the situation may be notified to the labor inspector to say the situations within 1 to 3 days. The seconded employees may also bring the case before the labor court. And disputing regarding remunerations may cover up to 3 years prior to the actions. A focus on the remunerations. So the minimum wage is an amount of 1,747 euros per month. However, collective bargaining agreement usually provides for conventional minimum wages for a higher amount. And in this case, it's this amount that should be applied to the seconded employee. The French social charges is a high level in France. It represents around 22% for the employer and 30% for the employer. And the median salary in France is up to 2,500 euros per month. That means that the net amount to be paid to the employees is 1,957 euros. And the total cost for the employer, including the net amount, the social charges for employee and employer, is more than 3,200 euros. what about the seconded employee social security? The basic principle is that the seconded employee is covered by the social security system of his country of origin, and social security contributions are paid in the country of origin. In the event of an accident, the seconded employee and his family may receive medical treatment in France. To do that, the seconded employee must be registered with the French social security system, and the employer should pay the social security contributions to the Centre National des Firmes Étrangères. Sorry. Except if there is a joint agreement between France and the country of origin. If the employee is a French tax resident, so he should pay taxes. He should pay taxes in France unless there is a tax treaty between France and the foreign country. If the employee is not a French tax resident, he should be taxed in the country of his residence. And now it will be Spain time.
Thank you very much, Ariane. And you know, it's clear that France has sort of various protections for employees. You know, and this collective bargaining agreement sort of concept might be quite alien to people outside of Europe. Even in the UK, actually, it's not standard practice necessarily to have those. So, you know, thank you for that insight. I'm now going to hand over to Victoria Truchuelo from our Madrid office to give us a view from sunny Spain. Over to you, Victoria.
Thank you, Devan. Thank you, everyone. Well, you'll see a couple of things that will be repeated for Spain, as it is an EU country. So it's very similar to what you heard for France in terms of social security regulations and just the same as other European countries. However, there are some things that you really would need to seek advice on to check that whether Spanish law would apply or not. And the reason is that it is a quite protective law towards employees. So while a lot of people would like to leave in Spain, as an employer, you really need to seek previous advice to make sure that you understand what are the main issues coming from the Spanish law. So as Devan was saying, we're getting quite a lot of questions from some clients asking whether a person could work remotely while still being employed by a foreign employer. And the answer is yes. However, there are certain differences where you need to check whether there's a secondment. Is there a presence of the company in Spain that you can second an employee to that company? Is it simply a remote working position? And how long is the employee going to be rendering services in Spain? Because obviously it's not the same, just like a business trip than staying here to live even more than a year. In terms of the visas, of course, there are some immigration and foreign law issues to be analyzed. Even being an EU country, as mentioned by Ariane too, there are certain administrative issues that need to be complied to. But there are also some visas and permits for non-EU employees. Some of them quite new. We'll see them in a minute. So for Spain, what is the applicable law? Same for France. I mean, in principle, there can be a contract that is subject to foreign law, but in the end, it will, if the employee is rendering services in Spain, it will have to, the employer would have to respect the minimum rights that employees have in Spain. So such as minimum annual leave, working hours. We'll see a couple of those and how they work in a minute. There would be a couple of tax issues that need to be looked into. Of course, main one would be permanent establishment, depending on the time and the kind of the services that are being rendered by the employee. There might be a permanent establishment trigger, so that's something you might need to look into. And then health and safety regulations, very important in Spain for the safety of the employee, of course, and because the sanctions can be quite high if not respected. The option of the employers of record, this is something Devan was talking about. As said, in Spain, the problem is that there are certain companies that can offer you HR, payroll, tax services to help you in the registration as an employer in Spain. But in the end, the employee has to be an employee of the actual company that is benefiting from the services of the employee. Employers of record as such, like having someone hire the employee for you and running services for you, but hired by that third party, is simply not permitted. And there could be high fines for both parties, unless we're talking about a temporary employment agency, which are the only ones that have the permit to do so, to put an employee at the disposal of another company. So what do we need to know in terms of what applies in Spain that would apply to my employees when I send them there to work? Well, in terms of holidays, leaves, notices, you have a list here. So for you to know, 30 calendar days, that means 22 working days per year. There's a Spanish workers statute, but the collective bargaining agreements might set up something that increases this, enhances this rights. So you always need to look at the applicable collective bargaining agreement, but these are the minimum ones that would apply. Maternity, paternity leaves, not quite high compared to other jurisdictions, 16 weeks. Then the sick leave can be partially paid by the state, partially paid by the company. The notice period is quite small unless something is said in the contract. And then probably the most important information is about termination. So whenever that secondment or that working abroad situation ends, some employees tend to ask for them to be considered as Spanish employees and be treated the same because of the benefits of the terminations. So these are the severances. So in case of redundancy, there's a 20-day salary per each year of service. In case of disciplinary dismissals that are not fair, of course, I mean unfair disciplinary dismissals, which are, by the way, most of them in Spain, because it's really difficult to defend a disciplinary dismissal, it would be 33 days of salary per year of service. The calculation, and that's important, is made taking into account the gross annual salary of the employee at the time the termination takes place, and the seniority to be used would be from the first day of employment with that company. And when we say company, we would mean not only the time in Spain, but also the time abroad. So you really need to look into this kind of things before you send an employee to ensure that there is at least an agreement that covers all these kind of situations when the contract or the relationship ends. Social security costs, just as in France, in principle to be kept in the home country with the if there is an agreement between the parties. If not, it would have to be in Spain. The cost is approximately 36% of the salary, just subject that there's a cap there. So for you to know, any employee earning more than around 4,500 would not be paying Social Security over that amount. Social Security payment covers the basic health insurance in the country, so that's good. Still, we recommend offering a private insurance. In terms of immigration, Social Security, taxation, well, as I said, even being European, you still need to get some sort of administrative issues. So there has to be a foreign identification number. It's quite easy, but you need to get that. And then there's the new visa for digital nomads. It's just recently approved in December 2022, but there are certain requirements. You can see them there. It's for non-EU employees, so quite interesting for the UK-based people. They have to have a university degree, 3 years of experience. The work has need to be fully remotely, and then it is limited in principle to 1 year. There might be other extensions, but generally not more than 2 years. Social Security, I already touched base on that. But in cases of no secondment, I mean, there's where you really need to look into that. For the UK, nice to know that in principle, it's the same as before Brexit, because the UK-EU protocol on Social Security coordination still works the same. The only limit you need to know is that there's a 2 years maximum to maintain the social security in the UK and not in Spain. In terms of taxes, it would be good to obtain advice on taxation. In Spain, there are several regions. Per region, there can be a different taxation applying to the employee. Some special treatments may apply for expats. So that's something you might need to look into. And of course, permanent establishment in terms of the risk for the company. There's what we say is quite new because we didn't have anything before COVID, and it was passed this law about remote working. There are a couple of things that you need to know about remote working because it applies to those who render services at least 30% of the working time in 3 months periods. For those cases, you need an agreement. You need to put into that agreement what will happen if the employee doesn't want to continue, what would the percentage of the work, what will be the control. There's no particular allowance. Some people are asking that. Depending on the sectors, the collective bargaining agreements may set something like for banking sectors, of course, banking and pharma are the ones that pay more. So they ask companies that have remote working to pay can be around 100 euros per month. Other sectors like insurance pay around 30 euros per month. So that's not a big issue, but you really need to give the employee at least sort of the basics in terms of the computer, the phone, and that's apart from the allowance for remote working. Time registry is a general obligation in Spain, and it works for remote working. So you need to seek advice on that, to have an app that controls the working time that cannot be amended by the employee, because there can be issues there, if not in case of inspection, of course. And then there's the last thing that I would like to go through is the option of having the employee being a contractor in Spain rather than an employee, so having a mercantile relationship. It is sometimes a good solution. As I say here, it's quite a popular figure, but it has quite many risks because the employee needs to be, and we shouldn't call him employee or her employee, it has to be genuinely autonomous. Because in the end, if a court or a labor inspection or the employee himself says, listen, this was just a figure that we made up to avoid the company having to register in Spain or having to pay Social Security in Spain, then we may end up in the reclassification of the relationship as an employment one, and then having to pay the Social Security not paid, if there were salary differences, well, those salary differences, and then in case of termination, treating that contractor as an employee. So this is something that if you hear about it, we would highly recommend that we review that contract, make sure that the employee is working as a freelance, that there's no exclusivity, that they work for other parties, because those could be points of problem, let's say, for the company in case there's not a genuine relationship. And that's mainly it. I get back to Devan so that Nikolaos can continue.
Hi, Victoria. Thank you for that. And a couple of things stood out for me there is the termination payments, because everyone thinks about the beginning of the relationship and the contracts, etc. But you also need to think about the end, and even looking at disciplinary dismissals, 33 days of pay per year. It can be quite onerous. I can see that, and also this thing about the employer of record, I found that interesting as well. That wouldn't work sort of. It can have some benefits, but not the sort of full benefits as perhaps sometimes advertised. So thank you for that. Before I hand over to Nikolaos, I just want to remind everyone there is a Q&A tab, and please do feel free to ask questions. Put your questions in there. We will address them at the end, and remember to put your name. But your questions are anonymous, so don't worry, we won't be reading your names out or anything like that. So don't feel shy to put your questions. I'm now going to hand over to Nikolaos Kostikas, a partner in our Greek office, to talk about the position in Greece. Over to you, Nikos.
Thank you, Devan, and of course a great thank you to Ariane and Victoria for the very useful information shared with us up to now today. Good morning, everyone. Good afternoon or good evening, wherever you are. as from what I can see from our participant list today, there is a significant part of our audience based outside Greece. For those we have not met before or we have not worked together, I'm a partner of the Athens office of our firm. Watson Farrell Williams was the first international law firm established office in Greece back in 1984, and currently we have 74 lawyers working in our office in Athens, providing on-the-ground Greek and English law services to our clients. I'm very pleased to participate in this webinar and touch upon some of the main topics of queries our foreign clients and investors raise when seeing to Greek employment market. So we will start, we will navigate you through the following subjects. Are there special rules for foreign employees to enter into the Greek market? When finally the foreign employee becomes eligible to work from Greece, what shall be the applicable law in their employment contract? And having then analyzed those matters, we will end with a brief overview of the main mandatory Greek employment law rules and some local aspects for the social security laws. Let's start with the first question of a foreign employer. Could an employee enter into Greece and immediately starts working for a foreign employer? As you may expect, and having already heard the situation in France from Ariane and Spain from Victoria, for EU and EFTA citizens, there are no requirement for a separate permit for living and working in Greece. They have only general obligations to register with the local social security organizations, the employment electronic registry, and the tax authorities. On the contrary, the non-EU and non-EFTA citizens shall be entitled to work in Greece only with a working visa. The type of the visa depends on the nature of the work or services contract. We should always have in mind the general rule. Visa must have been issued before the employee enters into Greece. This can be obtained from the Greek consulates in the place of citizenship or residence abroad. However, there are exceptions based on EU or bilateral treaties between Greece and several countries for visa-free entry from about 58 countries for a period of maximum of 90 days. But for such citizens, work is still not permitted. They only limited in business activity, for example, conducting meetings or negotiations in the country for an employer abroad, concluding contracts or purchasing goods for export. This activity is always subject to the regulatory requirements of the relevant business sector. We have to underline, though, that breaching the visa requirements or the conditions for the application of the exemptions can result in significant consequences for the employer and the employee, such as obligation of the employee to leave the country, administrative fines, possibly for both, and a criminal offense against the employee. Further to the above, and as there is an increasing demand from foreign third country employees to move into Greece and work from Greece for an employer not based in the EU or any EFTA countries, the Greek state has recently introduced a special category of working visa, the digital nomads visa, through a fast-track, one-stop shop process to facilitate the quick access to the Greek employment market. The non-EU and non-FTA citizens can work in Greece with a digital nomads visa for a period of up to 1 year. When the visa has been issued, an employee starts working in Greece, the employee can apply for a digital nomads resident permit up to a period of 2 years, of course, with option of further renewals. The issue of this digital nomads visa has specific requirements. Working remotely for an employment abroad with information and communication technological means always should be in place a valid employment contract for at least the period of the visa. And mainly, we should submit sufficient proof of net income of the employee of at least 3,500 euros per month for the period of the visa, which may increase if the employee decides to bring with him their spouse or children. When an employee now has become eligible to work from Greece for a foreign employer, then the discussion comes to the terms of the employment contract, and to start with, to the choice of law applicable to such employment contracts. It can be contractually agreed between employer and employee which employment law shall govern the employment relationship. However, certain mandatory provisions of Greek law must always apply, for instance, in relation to maximum working hours, minimum annual leave, remote working, health and safety regulations, prohibition of discrimination, minimum wage, maternity protection. As this can obviously end to an employment contract with two applicable laws at the same time when an employee is to provide their services in Greece, we strongly recommend that the parties choose the Greek law as the governing law of their employment contract. What if now, if there is no choice of law clause in an employment contract? If there is no choice of law clause, the employment contract shall be governed by the law of the place wherefrom the employee provides their services. In other words, in the case of Greece, Greek law. Furthermore, in case of no written employment contract, or even in case of non-valid employment contract, a de facto employment relationship has been established, and the Greek employment law shall also apply. We come now to a very brief overview of the main mandatory Greek employment law rules. To start with, we should always make clear that there is no minimum time threshold for the entitlement to employment rights, which means that since the first day of employment, the employee enjoys the protection of full Greek employees' rights. Only in case of termination of an indefinite term employment contract, the employee working for less than 12 months on the same employer is not entitled to severance payment. Very important for this webinar attendees will be, of course, the rules for the remote working, which must be agreed through a written contract between the employer and the employee. In such a case, the employees shall retain same rights with employees with physical presence. In addition, they will have the right to disconnect from any electronic tools they use while providing their services after the lapse of the daily working hours. And also, this has been set as an obligation to the employer as well. All costs relating to the remote working shall be undertaken by the employers. The employer retains instructions and control over the work of the employee during remote working without, of course, affecting privacy rights. Both employees and employers should follow health and safety rules and measures. In addition, there are rules, of course, relating to maximum limit for working hours per day and per week, minimum time for rest per week and per break per day within the daily working schedule, and of course, minimum working days of annual paid leave. For dismissals, a mandatory procedure must be followed, which in case this procedure is not followed, the termination shall be null and void. The consequences in case of an invalid termination may be jointly or severally the increase of the severance payment, possibly a reinstatement of the working position of the employee, and or a full economic indemnity. One important development of the Greek employment law is the employer's right to terminate an employment contract with notice and place immediately the employee on garden leave, without this affecting the validity of the work contract. Last but not least, if an employee provides their services from Greece, Greek social security laws shall apply. The foreign-based employer shall be responsible for all related obligations, but there is the option that the foreign-based employer may agree in writing with the employee that the employee will undertake the payment of the employer's social security contributions on their behalf. Thank you very much for your time, and now the path is back to Devan.
Thank you very much, Nikos, for that. And yeah, I'm particularly interested in this nomad visa. It came up in Spain, it came up in Greece as well. And it seems that some of these destinations are really recognizing that cross-border working now is a real reality. It seems to be very sunny destinations like Greece and Spain at the moment, but we'll see where else such arise. So I found that interesting, because the UK doesn't have anything equivalent to that. So very, very different. Before we go into the Q&A, I just want to wrap up very quickly on the presentations. And what was clear is, even within Europe, there's key matters vary based on jurisdiction, and even across all the webinars, it was so very different from jurisdiction to jurisdiction in Europe, out of Europe, with Asia as well. And I know many employers are keen to accommodate their employees, when they make these requests. But what we would say is caution should be exercised. We're not saying say no necessarily, but think about the consequences, because there might be unintended consequences for you as an employer. I know you obviously want to accommodate the employees where you can, but giving them free rein to make that decision can be quite can cause unintended consequences. And we recommend, as an employer, you implement some sort of policy to govern working across borders, whether that's I want to take a full, I want to take a holiday and then tag on 4 weeks and work in a jurisdiction, or whether it's more on a longer term basis. What are the rules around that, and what do employers need? What do employers need to think about? And always make it at the discretion of you as the employer, because you might get to a stage where you might think certain jurisdictions, they're too complicated, or some jurisdictions you're familiar with, because lots of employees request that jurisdiction. We're getting a lot of requests for Spain, in English-based employers, with employees wanting to work in Spain. So you might get comfortable with a particular jurisdiction and say that the rules that there are fine. But this is something that's a new phenomenon. Employers are getting used to this. But do think about that. It's not a question of just saying, well, that's fine, let them do what they want as long as they do their work. So now we're going to move on to the Q&A part of our webinar today. Please do, there's still opportunity to put questions, so please do go to the Q&A tab and add any questions that you may want to have. The first question I want to tackle today is actually for Victoria in Spain, and the question is, in a secondment, is a secondment letter compulsory?
Oh, God, that's a good question. It is not compulsory, but as you may have seen, there's a lot of issues, and you were right raising that, and in what happens when it ends. So what we have seen is that if you have not only just like a regular letter saying to the employee you go to Spain, but you actually have a secondment agreement stating what goes on with holidays, what goes on with what happens when you finish, what happens with those allowances that you have while you are in Spain, and whether they are even included or not for severance calculation purposes. The end of the secondment and actually the end of the relationship is much easier, and it avoids in many cases ending up in court or just ending up in discussions. So while there's no law that says it is necessary, we've seen that in the end it is necessary.
Yeah, it's just one of those things, isn't it? That, you get an employment contract, a comment letter, etc., and you can make it very brief and very basic, but it's when the relationship goes wrong where all these things become issues, and employers wish they'd put more in there. So it's always better to have these things covered off from the start. I know obviously people don't necessarily want to think about the end of the employment, but these things are quite important.
Definitely.
The next question I have is for Ariane. What rules would apply in the event of dismissal? French legislation or the rules of the country of origin? Ariane.
Okay. The legislation relating to the dismissal is the legislation of the country of origin. It's not the French legislations, only because the employment contract still exists between the employee and his employer, who is not based in France.
Thank you, Ariane. And a follow-up question: are all seconded employees concerned by these, the main requirements you mentioned?
In principle, yes, except for a specific category of employee, what we call for senior executive. In French is cadre exécutif, a cadre dirigeant. A senior executive is an employee who have specific responsibilities, which importance imply a high degree of independence in the organization of the company. He is empowered to take decisions with a largely autonomous manner, and he receives remunerations at the highest level of the company. And for this specific category of employee, all rules apply except the working time and the rest period.
Okay, so for those, there are some concessions there clearly for these people at the top of an organization.
Right.
My next question is for Nikos. Is the employee entitled to bring their family, their spouse, children, etc.? And how much would this increase the economic resources that they have to demonstrate for that?
Thank you for the question. You mean about the digital nomad visa?
Yes.
Mainly. This is the most hot topic currently in Greece. There are options that they can bring their families, spouse, cohabitants, or children, and they should prove that they have sufficient net income of additional 20% for the spouse and 15% of the 3,500 euros per each kid, each child. The very good thing for this process is that it seems to be a really fast-track process, which means that from the date that you submit the full file to the Greek authorities, they are obliged to issue the visa in 10 days. So this brings, an advantage to foreign non-EU employees to move into Greece. And also they have tax benefits. It's not the time to analyze this. So it's a package of benefits for this type of employees.
Okay, so that is quite quick, the 10 working days for them to get it. Of course, they can bring their family. Could an employee be eligible for this nomad visa if they're already in Greece, or do they have to be outside of Greece when they apply?
That would be an issue in the very beginning because it is a recent new law established back in 2021, and they have covered this as well. And there is the possibility to apply when you are in Greece for any of the reasons that you have a valid presence, of course, in the country. So yes, the answer is yes. So you can apply even when you are under a different visa status, validly present in Greece.
Okay, that's good. It seems like a very good option then for Greek-based employees. Thank you for that, Nikolaos. I've got another question for Spain, Victoria. would an employee follow the home country for bank holidays or the Spanish ones? So I obviously raised that question at the beginning. So how does it work in Spain?
Well, actually there should be following the Spanish bank holidays, and we have 14 bank holidays in Spain on top of the holidays. So you really need to look into the place where the employee would be located, even if that person, if it's going to be remote, there's definitely they have to be somewhere. Normally, actually, they need to set up like the official place where they are going to be rendering the services. And if that's Madrid, that's Barcelona, that's Valencia, wherever that is, you need to respect those local holidays. There have been some, we've seen some arrangements where because of the organization of the company, it just doesn't make sense that a person is not rendering services on a Tuesday in February because that's, I don't know, peak time in the UK if that person comes from the UK. These are the kind of things that we would recommend to put together in a document before the person is coming in, because while it should be compulsory to respect it, there is actually no problem in arranging that that person has those 14 days, but they might distribute them for organizational purposes in a certain way, if the person agrees, of course. But so yeah, well, the answer is yes, but there might be a sort of a wide margin there to negotiate in between the parties. Okay,
so sort of almost time off in lieu. So if you don't take it on the right day, you get it elsewhere. And 14 days, you know, seems quite generous. So that's good. It's interesting. It's regional as well, where you know where you're based, you could have something very different.
Yes, it is. That's something that all our clients are saying. So it's not for all Spain, and it's not even for the region. It's also for the specific city. So in the month of May, you may have like the local, which is I think it's a bank holiday also in France and maybe in Greece. 1st of May, that would be Labor Day for everyone. But then we have the one of the Community of Madrid. And then on the 15th, on the 2nd of May, and then on the 15th of May, we would have the city of Madrid. So only the city. So those are the kind of things that if you know that in advance, when you're having someone rendering services here, you can say, listen, we know May is a busy month for us in your home country. We need to arrange how you manage this, because you cannot be sort of out of the office for 4 or 5 days in a period of 15 days. It doesn't work for us.
Well, I've decided I'm going to come to Madrid and work in May next year. So I think that works.
And the weather is the best one, so we really, I would recommend that, definitely.
Another question for Ariane here. May members of the seconded employee's family join him or her in France?
Yes, for EU citizens or Swiss citizens who come to work in France, they may bring their family, so spouse, children under 21, or children of their spouse, and dependent direct ascendants of them, of the employee, or of their spouse. So an employee who's seconded in France can come to France with his global, very large family.
Okay, great. Thank you for that, Ariane. And the final question, I think, today is again for Victoria in Spain, and it's related to social security. So when paying social security in Spain, is the health coverage from the state limited to emergency services like an accident, for example?
Good, yeah, good question. Well, no, I mean, there's some people that if you actually come without a permit, and that's something that you might have heard in the news, or it's quite unpopular. So whenever someone is in Spain without the regular permit that allows them to live in Spain, then they can only access public health services, in cases of emergency. But an employee that is actually working or paying social security in Spain, they have full access to all kind of services. So emergency, non-emergency, and normally covers also the kids in the family. And that's actually one of the reasons why some of the people decide not to keep the social security in the home country during the time they are rendering services here, because the one of the good things of Spain is that the public health services is quite good, and so a lot of people would rather do that and save also the money of having a private insurance. I mean, a lot of people in Spain do not have a private insurance. I must say that the kind of clients that we have are companies that do offer that on top of what the state gives, but it's not something that all the citizens have, and that's something good to know, that you can actually save the money of a private insurance, because you would be fully covered for anything.
Yeah, and that links back to what I said, because if you've got an employer based in a different jurisdiction, their private medical might not even cover that employee whilst they're based in Spain, because it was, you know, specific for that jurisdiction. So if you can engineer it so they get access to the Spanish healthcare system, that might be a way around it, because it can be quite expensive to just get insurance for one employee in Spain, whereas, you know, in your country you've got a group insurance.
Of course, yeah. I mean, individual policies can be a nightmare in terms of the coverage, in terms of the cost, and you do save that if you have your social security in Spain.
Okay. Well, thank you very much, Victoria. And that's we're coming to the end of our session now, and the Q&A. So, firstly, I'd like to thank all the people who've attended this webinar. Those of you who attended the previous webinars as well. Thank you very much. It's been really great, you know, for me to learn about all the differences between the jurisdictions. Those of you who attended, you will receive a follow-up email with a feedback form. So I'd like you to ask you to please fill that in. Let us know how you found the sessions, what we could do better, and maybe topics for future. So please do complete that. The recordings are being made available of the session, so we can make those available to you as well. So thank you to all the participants, and finally, thank you to all the speakers today. Victoria, Nikolaos, Ariane, thank you for giving your insights today. So thank you very much for it. Thank you.
Thank you, Devan. Thank you, everyone. Bye.
Yeah.